An emotional support animal is not a service animal. ESAs do not perform trained tasks. Instead, they provide comfort, grounding, and emotional stability for people experiencing anxiety, depression, trauma, or other mental or emotional challenges. The Fair Housing Act, FHA, is a federal law that protects individuals with disabilities from housing discrimination. Under the FHA, individuals who have a qualifying mental or emotional health condition may be approved for an emotional support animal, ESA, as part of their housing accommodation. The FHA requires housing providers to allow ESAs in residences that otherwise restrict pets and prohibits charging pet fees, deposits, or additional rent for an ESA. Emotional support animals, ESA, provide comfort and emotional stabilization, support individuals with mental or emotional health conditions, do not require specialized training, are protected under the Fair Housing Act, FHA, do not have public access rights, are part of a therapeutic treatment plan recommended by a licensed clinician. Psychiatric Service Animals, PSA, are individually trained to perform specific tasks that mitigate a psychiatric disability, assist with conditions such as PTSD, severe anxiety, panic disorder, or major depression, are recognized as service animals under the Americans with Disabilities Act, ADA, have full public access rights, must perform at least one trained task directly related to the disability. Under the Fair Housing Act, FHA, housing providers must allow emotional support animals, ESAs, for tenants with a qualifying disability, ESAs in housing with no pet policies, ESAs without pet fees, pet deposits, or additional monthly charges, reasonable accommodations that support the tenant's disability-related needs, breed, size, and weight exceptions when the ESA is part of a verified accommodation. Landlords may not deny housing because a tenant has an ESA, require specialized training or certification, charge pet rent or pet deposits for an ESA, enforce breed or size restrictions that apply to pets. Under the Fair Housing Act, FHA, landlords are prohibited from denying housing because a tenant has an emotional support animal, ESA, enforcing no pet policies against an approved ESA, charging pet fees, pet deposits, or additional monthly pet rent, requiring specialized training, certification, or registration for an ESA, imposing breed, size, or weight restrictions that apply to pets, asking for medical records, treatment details, or a diagnosis beyond what is clinically necessary, rejecting an ESA based solely on personal preference or property rules, requiring the animal to perform tasks. Task training applies only to service animals. As a tenant with a qualifying disability, you have specific rights under the Fair Housing Act, FHA. These rights ensure equal access to housing and protect your ability to keep an emotional support animal, ESA, as part of your therapeutic care. Your rights include the right to request a reasonable accommodation for an ESA, the right to have an ESA in housing with no pet policies, the right to not be charged pet fees, pet deposits, or pet rent, the right to be free from housing discrimination related to your ESA, the right to provide clinically appropriate documentation without disclosing medical records, the right to be evaluated based on your individual needs, not blanket pet rules, the right to have breed, size, and weight restrictions waived for your ESA, the right to fair consideration without delays, harassment, or retaliation. Under the Fair Housing Act, FHA, landlords are permitted to request limited, clinically appropriate documentation to verify a tenant's need for an emotional support animal, ESA. This documentation must be reasonable and directly related to the accommodation request. Landlords may request verification of disability-related need from a licensed clinician, an ESA letter confirming a qualifying mental or emotional health condition, a therapeutic relationship with the clinician, the clinical need for an ESA, confirmation that the animal is safe to have in the housing environment, assurance that the ESA will not cause substantial property damage, basic information about the animal, such as type and size, when relevant to safety or property concerns. Landlords may not request medical records, treatment history, detailed diagnosis beyond what is clinically necessary, specialized training or certification, requesting an emotional support animal ESA accommodation under the Fair Housing Act, FHA, is a straightforward process. Tenants must provide clear, clinically appropriate documentation and communicate directly with their housing provider. Steps to request an accommodation. Notify your landlord in writing that you are requesting a reasonable accommodation for an ESA. Provide an ESA letter from a licensed clinician confirming a qualifying mental or emotional health condition, a therapeutic relationship, the clinical need for an ESA. Submit the documentation promptly to avoid delays in approval. Keep communication professional and factual. Request confirmation once the accommodation is approved. Important notes. You do not need to disclose medical records or detailed treatment history. You do not need to provide specialized training or certification. Your request must be evaluated individually, not based on pet policies. Under the Fair Housing Act, FHA, a landlord may deny an emotional support animal, ESA, accommodation only under specific, legally recognized circumstances. A landlord could deny an ESA request if the documentation is invalid, incomplete, or not provided by a licensed clinician. The animal poses a direct threat to the health or safety of others. The animal has a history of aggressive behavior that cannot be reasonably mitigated. The animal would cause substantial property damage beyond normal wear. The accommodation would impose an undue financial or administrative burden on the housing provider. The request is not related to a disability, or the tenant does not meet FHA disability criteria. The tenant refuses to provide required verification after being given reasonable opportunity. A landlord cannot deny solely because they have a no-pet policy. They dislike the breed, size, or type of animal. They prefer not to allow animals. They misunderstand ESA laws or ADA differences. If your landlord refuses your emotional support animal, ESA, accommodation, you have several options to protect your rights under the Fair Housing Act, FHA. Steps to take if your landlord refuses. Request a refusal in writing so you have clear documentation. Review the reason for denial to determine if it aligns with FHA guidelines. Provide updated or clarified documentation from your licensed clinician if needed. Restate your request professionally and reference your rights under the FHA. Submit a formal reasonable accommodation request if you have not already done so. Document all communication, including emails, letters, and dates of contact. If the refusal violates FHA protections, contact HUD to file a housing discrimination complaint. Reach out to a local fair housing agency for guidance. Consult with a legal professional for case-specific advice. Maintain records of all interactions and documentation. Important: a landlord cannot deny your ESA based on personal preference, pet policies, breed restrictions, or misunderstanding of ESA laws. Emotional support animals, ESAs, play an important role in supporting individuals with mental and emotional health conditions. The Fair Housing Act, FHA, ensures that tenants with qualifying disabilities have the right to request reasonable accommodations and live with their ESA without discrimination. Understanding your rights, knowing what landlords can and cannot require, and following the proper steps for documentation helps ensure a smooth and lawful accommodation process. If challenges arise, tenants have clear avenues for resolution and protection under federal law.